Yeah. Hi, everyone. Oh, is this working? Hello. Hello. Hi there. I think this works. Hi, everyone. Thank you so much for coming. My name is James Ferguson. I'm the Executive Director of Barristers' Council this year. I want to briefly go over what Barristers' Council is and then explain what you're going to be hearing today at the showcase. First of all, so Barristers' Council is the umbrella organization for our three divisions that compete around the country and around the world on behalf of Georgetown. You have the Trial Advocacy Division, the Appellate Advocacy Division, and the Alternative Dispute Resolution Division. You'll be hearing from all three of them today. They'll be doing a little bit brief overview about what they do, and then they'll do a demonstration to show you what they do during their competitions. What Barristers' Council serves to do is we provide the money to those divisions so that way the university is paying for all your travel, the competition expenses, etc. Almost all the costs of your competition will be covered by the university, minus things like your own food while you're traveling. After the divisions speak, you'll then be hearing from our managing director, who'll go over the details of the logistics to try out and some of the details there. And then we hope that you'll join us afterwards over across the street at Billy Goat for a happy hour to hang out, meet some of our members, and enjoy some nice beer and wine. So with that, I believe the first one is Trialad. Yep.
Hi, everybody. My name's Jordan. I'm one of the directors of Trialad.
I'm Jackie. I'm the other director of Trialad.
Thank you guys for all coming today. Let's see what these slides say. All right, so Trial Advocacy Division, we do trials. That's what's in our name. It's like what you've seen on TV. It's pretty self-explanatory, but we compete in mock trials all across the United States. You'll get to travel with a team of people from here to go compete in different tournaments against different law schools. You learn litigation skills, so whether you actually want to be a trial lawyer or somebody or a litigator or even a corporate lawyer, you'll learn how a trial works, the rules of evidence, how to argue motions in limine, all kinds of different stuff that you can use in any facet of the legal profession. Obviously, you'll boost your public speaking skills. You get up in court, do a lot of different pieces of what real trial attorneys do, so your public speaking will become a lot better. And one of the benefits of our division in particular is that we're coached by real attorneys. So every team has a real attorney who's coaching them, at least one, including the Assistant Attorney General of the United States, a senior partner at Wiley Ryan, Georgetown professors, associates at big law firms, prosecutors, public defenders, all kinds of stuff. So we got a lot of people who are there to help us out and a lot of good connections for you to make as well.
So we are a very good program. Right now, we're ranked 5th by the U.S. News and World Report. We are one of the only top law schools that is ranked on the U.S. News and World Report as highly as we are. And there are a number of competitions, as you'll learn if you join our division, that are hosted across the country, like Jordan mentioned. And for the last year, we have been finalists in 3 of the best tournaments across the country, and those are listed there. So we win, we're good, you should join our team. And then I'll be introducing our Green Hall director, Jen Solomon, and she will tell you information about how to try out for our team and what generally that will look like.
Hello. First of all, welcome. It's always lovely to see that there's tons of interest in Barristers' Council. So my name is Jennifer Solomon. I am the Green Hall director, so I'm in charge of the tryout competition for the trial advocacy team. I have 2 assistant directors that help me. One of them is here. Her name is Elisa, if she can wave, and Erin Steele, who's not available, but you can reach all of us at. It's on the next slide, but at greenhall2018@gmail.com if you guys have any questions after the presentation. So the competition is pretty straightforward. It starts off with 2 tryout rounds. And that first tryout round is kind of, everyone will be presenting a closing argument. So essentially when you are watching Law & Order and you see them like at the end bringing all that evidence together and giving their little speech, that's kind of what we're going to be doing in our first tryout round. What we're looking for there is just, to make sure that you guys are good speakers. You guys have like a good presentation style and that kind of thing. And before we even move into that tryout round, we're going to have a, what is it called? a training session. So if you have absolutely no mock trial experience, that does not matter at all whatsoever. I actually had no mock trial experience before coming on, and now I'm running the tryout process. So we will be training each and every one of you before anything comes out. So if you don't have any mock trial experience, don't even worry about it. So that'll be our first round. The second round is more, we're looking at more of the technical skills. And again, there will be training before that process. So at that point, you're going to be arguing something called a motion in limine. So you're trying to argue against someone else to get something included into evidence or excluded into evidence. And we'll give you all of that material. You'll also be doing a cross-examination of a witness. So that's sort of like you're trying to figure out like if they're lying, if they're telling the truth, like something maybe in their past that may or may not have been, like that may or may not increase their credibility or take it down. So after that, we move on to the Green Hawk competition itself. So after the second stage, we are taking 16 to 24 members. So once you pass that second tryout, you've quote unquote made the team. But to stay on the team and to keep your place on the team, you have to compete in the Green Hawk trial itself. So after the 2 tryout rounds, we have the competition, which has 2 trial rounds, a semifinals and a finals. That's low pressure. It's just a lot of, we're just trying to get like nerves shaken out and give everyone like an experience of what we do as a team before you decide whether or not you want to take your bid from us. So there are, I think Margot's going to talk about registration a little bit later, but I'll leave that to her. Can we? Which I might mess up. So that's my name. So if you guys have any questions, please feel free to reach out to greenhall2018@gmail.com. And I will be, both of us, I think, will be at the happy hour after if you have any questions. All right, come say hi.
All right, so this last thing we're going to do is we're going to do a piece of a cross-examination. Like Jen mentioned, we do a lot of different pieces of the trial through this. A cross-examination is an opportunity for you as lawyer to ask an adverse witness questions to try to elicit facts that you might want to get. This is a cross-examination from the Tournament of Champions that Jackie and James and I competed in a few months ago. And so Jackie will explain kind of the context for it, and then we will actually do a piece of the examination.
So like you can see here, there's a sort of description of what was going on in this case. Here, the defendant, who was a sheriff of a made-up sort of sheriff's department, the Los Diablos Sheriff's Department, has been charged with obstruction of justice. And I will be playing the prosecution witness, who was a U.S. attorney, who oversaw an investigation that was conducted into the Los Diablos jail, which was run at the time by the defendant, Rory Vaca. And then, as you will see when Jordan is conducting the cross, the whole point of it is to show that myself as a U.S. attorney am biased and that I want to take down the defendant regardless of what the evidence demonstrates against him.
All right. Can you guys hear me? Is this cool? Back? Yeah? All right. John, I see you taking a video of me up there. All right. Okay. Good afternoon.
Good afternoon.
Now, Mr. Ott, you know Rory Vaca, my client, right?
Yes, I've met him before.
You first met Mr. Vaca when you were a public defender.
Right, many, many years ago.
And while you were a public defender, you were representing an inmate, right?
Yes.
An inmate who was in Mr. Vaca's jail.
That's correct.
And that inmate was charged with assault, right?
Yes, I believe so.
He was charged with assault against a deputy.
That's correct.
A deputy who worked for Mr. Vaca.
Yes.
And in the course of representing that inmate, Mr. Ott, Rory Vaca, he came and he met with you, right?
Yes, we had a conversation at my office.
Well, you had a conversation, Mr. Ott, but when Mr. Vaca got there, he looked angry, right?
Yes, he seemed really, pissed off.
He cussed you out, right?
Yes, he did.
He called you names, didn't he?
Yes.
And you were just doing your job, weren't you?
Right. I mean, I was a public defender at the time, and I had to represent my clients.
And then after that, fast forward a few years, you moved to the United States Attorney's Office, right?
Yes, I did.
And when you went to the United States Attorney's Office, you were an assistant U.S. attorney, right?
Right. That's how you start out at a U.S. Attorney's office.
And when you got to that office, you still remembered Mr. Vaca, right?
I mean, I knew who he was.
You remembered that he had been angry with you, right?
Sure, I guess.
You remembered he had cussed you out.
Correct?
Remembered he had called you names.
Sure.
And so you went to your boss and asked him about Rory Vaca, didn't you?
I don't know what you mean.
You went to your boss and said, "Boss, I want to investigate Rory Vaca," right?
Right, I had heard that the Los Diablos Sheriff's Department was abusing the prisoners at the jail, and that's not, something that should be done.
So directing you back to my question, Mr. Rott, you went to your boss and you told your boss you wanted to investigate Rory Vaca, right?
Right, and the abuses that were happening at that jail.
Your boss said no.
That's correct.
But then a few years later, Mr. Rott, you became the boss, right?
Yeah, I went up in the ranks, eventually became the U.S. Attorney.
So you became in charge of the whole department, right?
Yes.
And in your capacity as the U.S. Attorney, it was your job to approve investigations, right?
Right.
Your job to oversee investigations, right?
Yep, that's in the job description.
And in 2010, you still remembered Rory Vaca, right?
I certainly did not forget who he was and what was happening at his jail.
You remembered that Rory Vaca had come into your office all those years earlier, right?
Sure.
You remembered that Rory Vaca had been angry with you.
Yes.
Remembered he had cussed you out.
Yes.
Remembered he had called you names.
That is correct.
And so in 2010, you approved an investigation into Rory Vaca, didn't you?
No, I approved an investigation into the Los Diablos Jail and Sheriff's Department.
The jail that Rory Vaca was in charge of, right?
Yes.
You were determined to investigate Mr. Vaca, weren't you?
Right.
Determined to take Mr. Vaca down.
Yes, for all the reasons that I said before.
Thank you. So we'll end there. So point being, right, you ask this adverse witness questions. They're all leading questions. Obviously, this cross goes on for a lot longer. But that's one of the things that you'll get to do here. You get to construct that cross and write it, write questions and write chapters with your coaches that you work with. And then you kind of have to adapt to what the witness does, think on your feet, and ask different questions based on what they do. So that's part of what we do. If you guys are interested in trial ad at all, come talk to us afterwards. We have a bunch of members. If you guys want to raise your hand, everybody who's over there. A bunch of people here from our team. Mike's here too. Feel free to come talk to us, and we'll be at the happy hour as well. So let us know if you have any questions. Thanks, guys.
Hi everyone, my name is Mackenzie Newman. I'm one of the directors of the Appellate Advocacy Division.
And I'm Nicole. I'm the other director.
We usually call it moot court, but this is fancier. We call it moot court. Moot court is we argue an appellate brief, and so you guys will actually do this in LRW this year. It's the same thing. You a lot of times get a packet for the competition that we run. It's a closed packet. For a lot of the competitions we go to, it's open, and so you only get a couple pages of facts and then what the question is, and then you do your own research and write a brief. Usually you have about a month to do it, and then you submit the brief, and then you go to the oral argument rounds, and they can be pretty much anywhere. Nicole and I are going to Houston next week for our competition, but our competition we went to last year was in Baltimore, so sometimes they're close, sometimes they're really far, sometimes they're in DC. And at the oral argument rounds, you'll have a panel of judges. Most of the time they start as practitioners or district court judges, and then as you get through the competition, the final rounds will have appellate level judges. Sometimes the final rounds of the big competitions at the national level will have really high profile appellate judges or Supreme Court justices. So it's cool to be able to argue in front of real judges. And you usually do a couple rounds and they weight both the brief and how you do an oral argument to see which teams advance. So it's basically the same as the competition that we run, which we'll talk about in a second.
So this is a little bit more about just the logistics of being on the team. The only way to compete in interscholastic appellate advocacy competitions, and I think this is the same with the other divisions as well, you have to be on our team. And as Mackenzie mentioned, we have a lot of competitions throughout the year. This semester, we have 24 different teams going to competitions all over the country. And it's on a variety of topics, like this slide says. Sometimes it'll be a sort of a generic competition where the topic, you won't know the topic until you get the packet. Other times the competition will center around something really specific like criminal procedure, sports law. There are some gaming law competitions. So there's a whole variety variety of different things that you can choose to compete in. And we compete as 2Ls. Almost everyone will compete their 2L year. And then there's an option to compete again your 3L year if we have the space and the money and if you are willing to do it again. But it's a lot of fun. So, right. And then our teams are coached by 3L students who have competed in a competition their 2L year, and sometimes by practitioners as well. So we have some specialized competitions, like I mentioned, like our bankruptcy competition, and we have a pretty prominent bankruptcy attorney that comes in and helps our team prepare for that competition. And we're ranked 5th in the country.
So our Beaudry directors this year are Elena Lewis and Jordan Harris. I think Elena's here. There you are. She's waving back there. That's Elena. She's going to be running the competition this semester. Nicole and I did it last year. It's a ton of work. Very grateful that Elena and Jordan are willing to do it this year. But you'll get information about signing up. I think people have already registered. Registration is open, so if anyone knows that they want to try out for any of the barristers divisions, all of them, whatever, you can register. It's live. Our process, you write a brief. Again, the packet is closed for our internal competition, so you'll get the fact pattern and the cases, which makes it a little easier because you don't have to go find all the cases.
And in fact, you can't.
Yes, it is closed and you can't look outside the packet. Right. And so you write a brief based on the materials that you're given. You all get to choose whether you want to write for petitioner or respondent. It usually breaks down like 50-50. People choose either side because we usually try to pick a case that it really could go either way. We don't try to pick a case where it has an obvious winner because that's no fun for moot court. And so you submit the brief. The brief is written over spring break, so you have some time to do it. You won't be in class, unfortunately. If you have any fun spring break plans, then you'll be writing a brief like in Miami. But you write the brief over spring break and then you turn it in, and then you argue the case in the preliminary round, and then we make a really big cut at the preliminary round, and then we have a quarterfinal, semifinal, and final round. The rounds get a lot smaller each round. The final round is only 4 people, and we have real judges come in for that round. So we've had DC CA, DC Circuit judges, DC District Court judges, and then often we're able, because we're in DC, we're able to get the actual litigant that's going to argue the case that our case is based on at the Supreme Court, which is always really fun. Our year we had one of the litigants that was doing our case moot us, and he was on the other side of what I was arguing, which was really terrifying because I knew that he had a personal interest in the case, had argued it, or was going to argue it, and disagreed with my position on everything. So it's really fun, though, because you get to argue in front of real people, and they ask questions that you're not used to because you moot with your friends usually and get prepared for it, and then you have real judges come in, and they usually have a lot of really interesting hypotheticals. So it's really fun. That's a great round. But then semifinals will be in front of the leadership of the moot court team and sometimes some outside people, and then the quarterfinals and prelim rounds are usually in front of other students. So that's how the competition is structured. Anything you want to add?
Nope, just like it says, we usually take about 30 people. These are just the dates of the competition. They're on flyers that are either posted or will be posted. You'll see them on emails you get from the school, so just look out for them. Basically, the most important one is when registration, obviously, which is now, and then the packet gets released on the 9th of March.
Yes. This is the email address that Elena and Jordan have. So if you have questions about the competition specifically and tryout process, you can email that. What I will say, though, is that we are having an information session as it gets closer, because we don't start until March, and so we still have a little bit of time. So don't panic yet and start emailing them a lot of questions, because we might be able to answer them in the information session, and you'll get information about when that happens. Was that on the slide?
Yep.
No. Yes?
2/8.
Oh, 2/28. That's when you'll get all your questions answered.
Okay.
All right, and now we're going to do a short demonstration, if Claire and Gary can come up here. Nicole and I coached Claire and Gary for a competition that we went to in November. They're amazing, and they did a really great job. Basically, the case is about 2 people that went to a protest and they rented a car.
Can't hear you.
Sorry? Oh, sorry. It's about 2 people that went to a protest and they rented a car, and one of them was the licensed driver or the authorized driver of the rental car, but the other one was pulled over driving it. And so Claire's issue is about the Fourth Amendment and whether there's a expectation of privacy in a rental vehicle. It's based on the case United States versus Byrd, or Byrd versus United States. that is at the Supreme Court, and it's being argued like next week or something. Last week? Okay.
Yeah.
And Nicole and I went to the moot with the Supreme Court Institute last week. So it's a really real issue, and it's very exciting. Nicole and I are going to be judges with Gary. I know. It's okay. They want me to take this. I don't know how to use this thing. Okay.
We're just going to get a timer.
That works.
Oh, and, sorry. Okay. We really don't have it together today. Claire's going to do 5 minutes on one side and then 5 minutes on the other, because in every competition you have to argue both sides of the issue. So we're going to give her like a 30-second break in between so that she can collect her thoughts for the other side. Okay.
May I proceed? Madam Chief Justice, and may it please the court. My name is Claire Cahill, and I represent the petitioner on the Fourth Amendment issue. Mr. Nightingale's claim would fail under any of the three tests articulated by the circuit courts on this issue. But we ask this court to hold that a person must either have readily apparent permission or a legal, lawful authority to drive a rental car in order to establish a reasonable expectation of privacy.
Wouldn't having his name on the rental agreement be readily apparent to the police officer?
Your Honor, it might, but in this case, Mr. Nightingale's name was not on the rental agreement. Instead, Ms. Sparrow was actually the one who signed the agreement, and only her name appears on the rental agreement. Now, Mr. Nightingale did pay for the rental vehicle, but that's his only association with the vehicle. That falls...
His only association, right? I mean, he has his credit card on file. If something were to happen to the vehicle, presumably he would be responsible for it.
Yes, Your Honor. The only association is that credit card that he used to pay for the rental vehicle. However, this still falls short of the test that we're asking this court to adopt for two reasons. First, Mr. Nightingale did not have readily apparent authority to drive and control the rental vehicle. And second, Mr. Nightingale forfeited his lawful property interest by disassociating himself with the vehicle.
Jump to that second one. That second one's a little concerning. You're saying that he lost his property interest because he violated the contract. But what if the contract had some kind of gas rule that said you can't fill this with diesel gas, and he did that? Does that also disqualify his property right?
Your Honor, he didn't lose his property interest by violating the contract. He lost his property interest by disassociating himself with the vehicle. In United States versus Borough, the Fifth Circuit recognized that a person who actually purchased a vehicle but put the title in somebody else's name and didn't drive the vehicle sufficiently disassociated himself with the vehicle such that he forfeited a reasonable expectation of privacy in that vehicle.
But counsel, didn't they only have the vehicle for like 2 days, and wasn't he basically with Miss Sparrow the whole time? It wasn't like they rented it for months.
Correct, Your Honor. It's unclear exactly how much of the time he was actually in the car with Miss Sparrow, but he did disassociate himself with the vehicle by not appearing anywhere in the contract, by not putting himself as being an authorized driver, which he easily could have done.
Counsel, doesn't that happen all the time? I mean, the other side has a bunch of facts in their brief about how prevalent it is that people drive other people's rental cars, and so should the Fourth Amendment really turn on something that happens so commonly?
Your Honor, yes, just as it's common for a passenger to frequently be with another person in a car, but that doesn't give them a reasonable expectation of privacy, as this court held in Rackus versus Illinois.
So under your rule here, if Miss Sparrow, who was the authorized driver on the agreement, if she was a passenger in the vehicle, would she have had an expectation of privacy?
She would have had an expectation of privacy by being having readily apparent possessory interest in the vehicle. In Rackus, this court held that there are two different ways that a person can have a reasonable expectation of privacy. One is through a property interest, and then one is through having a possessory interest. By appearing on the contract as the authorized driver, then Ms. Sparrow did have the possessory interest and could assert a reasonable expectation of privacy. But Mr. Nightingale was not on the contract and could not be seen as having readily apparent authority. In fact, in this case, he doesn't even have explicit permission from Ms. Sparrow to be driving the vehicle.
But he has implicit permission, right? I mean, they're traveling companions. They were in the car together throughout the rest of their trip. So it seems consent is pretty implicit here.
Your Honor, there's no indication in the record, especially on page 4 of the record, that Ms. Sparrow ever gave any sort of permission. Instead, Mr. Nightingale only assumed that it was okay with Ms. Sparrow. No circuit court has ever held that that a person has legitimate possessory interest in a vehicle when they do not appear on the contract itself or have explicit permission from the authorized driver or the owner. Therefore,
What is the minimum amount of permission that makes it explicit?
somebody actually asserting that it's okay for them to drive, or it being easily verifiable by a police officer. For example, in Sanchez, the First Circuit held that where there was no easily verifiable way for them to assert a legitimate use of the vehicle, then that person did not have a reasonable expectation of privacy. Because he neither had a legitimate possessory interest or property interest, we ask this court to reverse the ruling of the 14th Circuit.
Thank you. All right, now hold on. She's going to do.
Now we'll give Claire 2 seconds, maybe, and make her switch sides.
Oh my goodness.
It usually doesn't happen quite this quickly, but it can usually be within hours or so.
Government bad, Mr. Nightingale good.
Yes.
Ready?
Yep. Madam Chief Justice, and may it please the court. My name is Claire Cahill, and I represent the respondent, Mr. Nightingale, in the case at bar. The standing to assert a Fourth Amendment right is based on reasonableness. The question is whether a person's expectation that something will remain private is what a reasonable person in society would also expect. Mr. Nightingale's expectation was reasonable for 2 reasons. First, society expects privacy for someone who pays for a rental car and then uses that car. And second, society expects that someone who is driving alone in the car with implicit permission would be free from intrusion.
What's your authority for those principles?
Your Honor, in Rackus versus Rackus versus Illinois, the court held that a person who has either a property interest or a possessory interest in a vehicle has a reasonable expectation of privacy.
Sure, but you said that society expects that if you're in a rental car and you pay for it, then you should have an expectation of privacy, and that seems like a much weaker property interest than we had in Rackus. And so, does Rackus really stand for that principle, or is this a new issue entirely?
Your Honor, it is a new issue, but it does base itself in the Rackus decision. There is a property interest when somebody actually pays for a rental vehicle or a hotel room or something like that, and then uses it. And that's something that this court did uphold in Henderson versus United States in regards to a hotel room. And so there is definitely a property interest associated when a person is using a rental vehicle. In this case, Mr. Nightingale actually paid for the rental vehicle, and therefore...
Right, but didn't he disassociate himself when he listed someone else, or when he allowed someone else to be listed as the authorized driver?
Your Honor, this case can be distinguished from Borff in one particular way. In Borff, the person not only put the title in somebody else's name, but then was not in the vehicle when the vehicle was searched and was not driving the vehicle at any time. In this case, Mr. Nightingale might have disassociated himself on paper, but he didn't disassociate himself when he was actually from...
So how is a police officer in the field supposed to know that?
Your Honor, the officer has some sort of obligation to at least call the authorized driver or call the rental company and actually verify that this person...
So they just have to try? Do they have to get in touch with the person that they're trying to reach?
Your Honor, it's possible that they wouldn't be able to get in touch with the person. In that case, probably the easiest thing for the officer to do would be to obtain a warrant and avoid the Fourth Amendment issue altogether. But the officer, like in Sanchez versus United States...
But traffic stops are quick. Traffic stops, that's the reason that the Fourth Amendment is so diminished in the traffic stop scenarios, because it's a brief seizure on the side of the road that is supposed to last such a short amount of time. How are they going to go get a warrant to check a car that the car itself can move so quickly from the scene of a possible crime?
Well, a traffic stop may be quick, but searching the car isn't necessarily a quick thing. And when the officer goes beyond just stopping the vehicle and seizing the person at that moment, then when to actually search the vehicle, then it's a different sort of issue. And in that case, the officer could have asked Mr. Nightingale to step out of the car, which he did, and then search and wait until the warrant is received and then actually go and search the vehicle. And so in that case...
It seems like you're underestimating how much of a burden that is on police officers when they're doing standard traffic stops on every third car. I mean, that's a huge line of cars that are waiting, and they have to wait every single time there's a rental car. Talking about 2 hours, 3 hours of delays. Do we really want to be doing that to people?
Your Honor, it's a question of balancing officers' convenience versus Fourth Amendment rights, and in those cases, Fourth Amendment rights do trump. Just because the officer is stopping every third vehicle doesn't mean that they want to search every single vehicle. And so Mr. Nightingale, in this case, had a Fourth Amendment right in the vehicle. He had a reasonable expectation of privacy in the vehicle, and the officers needed to actually observe that and follow the procedures. And
Well, that's the question we're here to answer, isn't it, counsel, is whether he had a reasonable expectation of privacy. You seem to be assuming the conclusion.
Your Honor, that is the question, but Mr. Nightingale did have a reasonable expectation of privacy, both through his property interest and also by having a legitimate possessory interest of the vehicle. Mr. Nightingale was driving alone in his vehicle, knowing that the authorized driver was under arrest in a police station for a number of hours, and knowing that the rental car company was not expecting the vehicle back at that time. Considering those factors, Mr. Nightingale could reasonably assume that nobody would enter the vehicle.
Counsel, I want to direct you to a hypothetical, if I could. I'm wondering how this applies to places not just vehicles. So, for example, I used to be on my parents' cell phone plan, and they don't have my phone in their hands. But if they take my phone, does that mean they suddenly have a right of privacy in my phone?
Your Honor, if they are paying for the phone, then they do have, they would be able to assert a reasonable expectation of privacy within the phone. Thank you, Your Honors.
Yay.
Hi, my name is Ali Genoa, and I, along with Ashley King, direct the ADR team at Georgetown. So, first question, I guess, is what is ADR? I think it's probably the least known discipline or team at Georgetown. So ADR, or Alternative Dispute Resolution, very broadly are all of the processes that attorneys engage with that aren't specifically trial. And as most cases don't wind up getting to oral argument at trial, ADR skills become incredibly important for practicing attorneys. Specifically, we discuss ADR with negotiation, mediation, and arbitration. So negotiation's pretty intuitive. Parties negotiate complex issues across the table from each other. It sounds really intuitive, but it's actually pretty complicated. There are really legitimate tools and skills that you really should know to negotiate, especially at opposing counsel. In competitions, you will either play the role of counsel or client, and you'll have a really complicated scenario you'll have to address. And questions like, who speaks first in a negotiation? What's the opening offer? What's the tone? What's the strategy? What's the pace? What's the leverage? These questions are really hard to address, and you need to understand sort of systematically how to do that, and the ADR team will help you build those skills, and we compete in pretty awesome competitions. Mediation is really similar to negotiation, except it's more of an informal process. So parties are still negotiating issues, and in competitions you will still represent either the counsel or the client, but there'll be a third party called mediator that will sort of orient the process. Mediators facilitate negotiations. So as a competitor, you're going to utilize the mediator to help you address your issues, to help clarify issues to opposing counsel and client. Sometimes the issues that you're encountering are sort of emotional. I did mediation with someone who was in a car crash. He came in with a bandage. You can sort of act in these scenarios. It's kind of fun. But in the real world, personally, I'm very passionate about mediation. I think oftentimes it becomes a process that clients and attorneys use that becomes something where people actually get an approximation to justice. You really do get to sit across the table with the person that's wronged you and find a resolution. These processes are really efficient and effective. I interned with a JAMS, which is an international ADR firm, and I sat in on a commercial class action dispute that was resolved within a matter of hours for multi-million dollars. It's really an awesome process. Arbitration you guys have probably heard of in civil procedure, in life. Arbitration is incredibly important to understand. You are probably already mandated to do arbitration if you have a cable bill, a phone bill, if you've been employed. There are mandatory arbitrations as ways to resolve conflict internally in organizations. Basically, arbitration, it is a formal process. In competitions, you do preside in front of, not a judge, but it's an arbitrator. So you will learn oral argument argument, cross-examination, closing, evidence. You do have to know the rules of evidence, and it becomes something that is pretty exciting. You do get those or language skills. In general, all of these require a lot of communication skills and understanding of these processes. For the team, we travel across the world. ADR is something that is increasingly, like I said, relevant, especially internationally. International arbitration in particular is something, if any of you are interested in international work, arbitration is something you have to know. We do compete at VIS, which is a really prestigious international competition. We have practitioners who come to coach. Someone at Jones Day is with us now, and they do say that if you have VIS on your resume, it's something that people really notice. It's very well known in the international arbitration world. We're also traveling. I'm personally going to Paris next week or in 2 weeks for the ICC mediation competition. I'm going to be at the table with a team from Kenya and a team from India, so I'm going to have to really work on my communication skills. It's very exciting. We go to Hong Kong, Vienna, Dublin. ADR doesn't have a formal U.S. ranking like the other teams do, but Georgetown is very competitive. We get invited to some of the most prestigious competitions in the world. It's a really fantastic team. We also go across the country, Houston, New York. We have our baseball arbitration team in New Orleans. Actually, today they just left. Baseball arbitration, if you're interested in sports, very awesome process. If you like baseball, this is something for you. As far as how to get on the team, we do Bellamy. So Bellamy is a negotiation competition. So of the 3 competitions that we engage in, negotiation is the most intuitive, but we do teach you how to do it. We will have an information session and a training session. It's a little later in the semester. It shouldn't interact with any of your breaks or briefs or anything like that, so it should sort of fit in. And if you have any questions, information session is a great place to get it. Essentially, there are several rounds. We have preliminary rounds where you compete twice in negotiations. If you make it to the semifinals, congratulations, you're on the team. After the semifinals, if you make semifinals, you'll go on to compete for the finals, and that's 4 competitors. And winning the Bellamy competition is a really fantastic thing. It's something people put on like their LinkedIns. I've seen people still put Bellamy finalist. It's all around a very exciting thing. The Bellamy competition is hosted in Hart. We do have practitioners in DC come in and judge. So this is the Bellamy email address. If you guys have specific questions, feel free to email. Again, the information session will also have more information for you. And for our demonstration, I'm going to bring up, so we actually won the ABA negotiation regional competition. We're going to be going to the finals in Chicago in just a couple of weeks. And our finalists, our duo, who are fantastic negotiators, are going to do a demonstration for you. It's a little later. They're going to go over the facts of the case, but basically what they're going to show you is just a simulation of what a negotiation is in a competition setting, and they're going to explain more about it. But I hope I see you guys all at tryouts. So thank you.
I think you guys can hear us, but they told us to put the mic on.
Yes.
So thank you, Allie, for the wonderful introduction. So my name is Rachel Lee.
My name is Suzanne Zachariah.
And as Allie mentioned, we're going to be showing you a tidbit of a negotiation. And I know it's been a lot to take in today, so we're going to make it short and sweet. But we're going to show you 3 basic elements that we use globally in most of our negotiation competitions. The first one is opening remarks, where each party highlights their client's interests and build rapport. The second element is agenda setting, which sounds simple, but is a key way to prioritize the issues that you will be negotiating and also control the dialogue in the negotiation, hopefully in favor of your client. And the third part is the actual negotiation itself, where we will be working with each other, the keyword is with, not against, to reach a mutually agreeable outcome on all of the issues that we set in the agenda.
So the basic fact pattern that you're about to see is about Lyric Opera, which is an opera house that has just lost its lead soprano mere weeks before a production of Norma is supposed to take place. And so, can you hear me?
I don't think that one, yeah. There we go.
I will project, which is what they teach you to do. And so I'm representing the Opera House, and Rachel will be representing Sally Soprano, who is a more mature soprano who has not had a lead in a couple of years. She's desperate for this. It'll lead to further opportunities. She's willing to work for free, but also wants to be compensated for her work. So that is the general fact pattern, and both parties are aware of these facts going into the negotiation. Now, something that you should also look for, and something that we will be trying to gauge from each other, especially as we lay out the agenda, are our confidential facts. So I know certain things about the Opera House's priorities, and Rachel knows certain things about what Sally Soprano hopes to get out of this employment negotiation deal. And throughout the negotiation, and especially at the beginning, we're going to be asking each other fact-finding questions to try to pick up on those priorities, because at the end of the day, like Rachel mentioned, this is not supposed to be adversarial. We are supposed to come to a negotiation. We're supposed to reach a deal. And you'll find in many competitions that you're rewarded for doing that. So without further ado, we're going to go into just a little brief presentation about what this can look like.
Hi.
Hi, I'm Suzanne.
Nice to meet you,
Nice
Suzanne.
to meet you,
Rachel
too.
Lee. So as you know, Sally has worked with lyric opera before and actually performed in this very play, Norma. She has played the lead and she's happy to play it again. And I understand you're in a bit of a difficult situation where your lead, what was her name, Renata Rising Star, has dropped out a little last minute. And Sally would be really happy to play this role, especially since she has this age and experience now. She feels that she can play this better than ever.
Well, Rachel, on behalf of my client, I'm really thrilled that we're able to be here today. I know we've worked with Sally in the past, and my client tells me that she has been developing that soprano, working on her trills. So we are really excited to see if we can come to an agreement here today about how she can fit into the upcoming production of Norma. And before we get into this, I just have a few questions about Sally, because I know she hasn't really had a lead in the past couple of years. So how is her voice, and has she kept up with her vocal training?
So I'm glad you mentioned that, Suzanne, and I'm happy that Lyric will be willing to work with Sally. Although Sally has not had a lead position in a while, she has always took secondary roles. Even in the past year, she has been in many productions, and that helped her kind of continue her training, keep good vocal conditions for her roles. And since this is a role that she has taken in the past, she's very familiar with it, very confident in playing it. So I think Sally would be a perfect fit for it. But for the sake of our discussion, Suzanne, before we jump into the roles and the compensation, I wanted to just make sure that we are in agreement about what issues we will be discussing today.
Sure.
So I was hoping to discuss basically the expectations of the role itself. We kind of touched upon it just now. What Lyric is seeking, I'm sure you have expectations about this, since this is an ongoing, very popular production, and how Sally, my client, can be best suited for the role. If you have any concerns or questions, like you mentioned, I'm happy to address them. The second one I wanted to talk about is the compensation itself. Sally feels really strongly about playing this role and would be happy to do so out of the goodness of her heart, but again, she is a very well-known, qualified singer, so I think some sort of compensation would be fair for our client. And finally, we have this history together working on many, many productions, and it is our client's hope that we can work on many more future opportunities together.
Sure, and I'm glad you laid these out. I'm very happy to start talking about Sally's roles, the expectations that we have as a theater, and also the expectations that she has as a performer. Obviously, we want this to be as smooth a process as possible. The next thing that you laid out was compensation, and you mentioned salary, but I want to be sure that we talk about additional compensation beyond just the number on the table. So laying out benefits and how Lyric can work with Sally beyond just that figure on the table, whether that's benefits or pay time off or vocal therapy. We want to make sure we address that because we have a lot to offer. We certainly want to continue the relationship in the future, and so I'd like to add on a fourth topic of discussion, which is a non-disclosure agreement, should this contract go forward. Does that sound okay with you?
That sounds perfect to me. I think our client would be happy to hear about the benefits that you mentioned and also a possible NDA agreement at the end.
Great, and just so that we stay on track throughout this negotiation, I'm going to be keeping a list of things that we discuss, and I'm also going to be keeping a list of what we've come to an agreement at, so that at the end of the day, we can walk away knowing that we've come to a good deal between Lyric and Sally.
And get it signed by our clients. That'd be perfect. Great. So on the role itself, Suzanne, earlier you mentioned some concerns about the condition of my client's vocals. Were there any other questions you have? I know that every production is not the same and you might have different themes or ideas that you have. Do you have any questions for our client?
You know, initially we did not see Sally in this role because she is more of a mature soprano, as you would say. But given that our situation has changed, we really see her in the title role as Norma.
Oh, great.
Is something that Sally would be interested in doing?
Yes, so is it fair to say that we both agree that Sally will be taking the main role in the production of Norma this year?
Well, subject to, of course, agreement on the rest of these
ideally,
items.
right.
But ideally, that is the role that we envision her in.
Great. I think we're starting off on a very positive note.
Wonderful. So with that, let's move down to compensation.
Great.
And we will
just stop there. So thank you very much, everyone. We wish you all the best. Hope you join the team.
Thanks, guys. So as James said, I'm the Managing Director of Barristers' Council. My name is Margaret Rasconi. I'll make this short and sweet, just a little bit of information about how to actually become part of one of these wonderful divisions, and then we'll get you guys off to some free food and free drinks shortly. So the sign up for registration is online. It's live now. You can register on your cell phone, on your laptop. It's tinyurl.com/barristers'council. Fill out the Google form. You can either pay online using Eventbrite, or you can pay with cash or check. In the Google form, you will tell us which one you prefer to pay with. You can pay right away with Eventbrite, or you can say I want to come back to it later. But you can go ahead and pay for all of that online if you want to. It's $30 per competition or $75 for all three. If you personally are facing any sort of financial hardship, you can email either me or one of our wonderful administration contacts, Maura, over here, and let us know, and we can waive those costs for you. But you can try out for all three, and that is a reduced rate. Like the division said, you would get an offer after each competition. So say you want to try out for all three. You could sign up, try out for Trial Ad, make the team. You can make Moot, you can make ADR, and that's great. But then at the end of the semester, you'll receive an email from either James or I asking you to choose one of the three to be a part of. But you can choose all three. I know right now you guys have had a lot of information thrown at you. They all sound great. They all are great. So you don't have to make up that decision, make up your mind right now about which one. You can try out for all three. You could try out for just two. You could try out for one. So that's really up to you. And just as a side note, remember that only 1Ls and 1Es can try out for Moot. Upperclassmen can try out for Moot in the fall next year. And another key thing to remember is that if you decide to pay in cash, or the time that you fill out the Google form, you can't fill out the Eventbrite information right away, come back to it before the registration deadline hits. Even if you want to try out for all three, but you don't want to make up your mind about it right away, you still have to register for each individual competition before that specific deadline. So you could register for just trial advocacy right now, as long as you do it before January 26th at 5 p.m. And then say later on you decide, you know what, hey, I do want to try out for Moot still. You can still do that. You just have to sign up before these deadlines. So just keep that in mind. And if you do want to pay via,
So if you are paying by cash, we will be tabling Trial Ad because we have the first competition. We will be tabling starting on Monday. But if you do not pay by January 26th and you still want to compete, we are, and you turn in your money after that date, we will hand you the packet after that time. So you just will have less time to prepare, if that makes sense. So you can still pay after that, but once we start with the tryout rounds, then we're not accepting any more money and we'll hand out that packet to anyone else.
So it sounds like Trial Ad definitely has an exception for that, but I know the other divisions, that's a set deadline. I know for some of them, especially for Moot, you only have over spring break to write that brief, so you want to get that money in to be able to get the packet right when it's released so you can get going and get started. So just keep that in mind. And like Jennifer just mentioned, there will be tabling. So if you do want to pay via cash or check, each different division has different dates that they've set up to table. Basically what that means is they'll be at a table in the first floor of McDonough outside the cafeteria to accept cash and check payments. If for some reason you can't make any of those days, some disaster hits and you're about to hit the deadline but you can't pay online, email me. We can try and figure something out. But if the deadline hits, other than if you work it out, I guess, with an individual division like Trial Ad, if the deadline hits and you haven't paid, even if you've registered on the Google form, then you can't get the packet. So just keep that in mind. So once again, you can register now, tinyurl.com/barristers'Council. If you decide you want to try out for all three now, great. If you decide you only want to try out for one, but then later you want to go back, again, that's great. Just make sure that you are selecting the divisions that you want to try out for, because we give them that information and we give them your names as someone that wants a packet and that has paid. Any more things? If any of you guys came in late and you still have questions, you missed some of the previous demonstrations, you can come up and talk to James or I at the end. Also, if anyone wants to pay via cash or check now, we're willing to do that. And other than that, that's it. So you guys are free to go. We'll see you at Billy Goat. Thank you.
Where's the other mic pack?